Welcome to the Business SOS podcast. This is Rich Sierra, President of the Florida Small Business Legal Center. This is the Thanksgiving edition of the podcast. As we're recording, it's a pre-Thanksgiving. It'll drop after Thanksgiving, but I don't want to miss the opportunity to wish every one of you a happy Thanksgiving and also happy holidays. And I truly appreciate you listening to me now for close to 2.5 years, and I hope the information that I provide to you has been helpful to your business. The last 2 episodes, we actually had some interviews that we ran, some reruns, I guess, for interviews that I believe that are valuable to you. I was traveling and had some court matters that I was not able to come in and do a live episode, but I appreciate you listening. Hope the information, the interviews that I reran were helpful to you as well. If you have not listened to them, they were from the beginning of when I started the podcast, but they were still timely episodes. So today I want to continue the theme of litigation. As you know, I do quite a bit of business litigation here in South Florida. So a lot of things that I talk about are litigation oriented, and there's so many different aspects of litigation that affect small businesses. So I want to talk about one of them. In this case, the topic today is why most small business lawsuits bleed money and how to stop it. And so I want to give you some strategies and how to address the cost factor in litigation. As I mentioned to you before, litigation is unpredictable. And litigation should be used as the last resort if the parties cannot come to some type of an agreement or understanding how to resolve the business dispute. Litigation should be used as the last resort simply because of the unpredictability of the outcome. There will be a winner and there will be a loser if you involve in litigation. If you take the case with a trial, there's no draw here. There's no settlement if you decide to go all the way. Number 2, the cost factor involved, and I have addressed that before as well. But the cost factor is one that in some cases deter a party from pursuing litigation. And the cost factor is also a reason why parties in most cases settle simply because they want to stop the bleeding. And the analogy I can give you is if you go into a toll road here, we have the Turnpike, we have 95 Express. And if you go in, depending on the time that you travel, it might be $1 or $1.50. So think about going to those toll roads and it's $1,000 every time you go. And sometimes you're sent back to square one, like a bad monopoly money. You start from the very beginning. So it's just, that type of unpredictability and the inability to forecast your costs makes it very difficult for a small business to plan how to approach a litigation case. And the question that I get often is, how do I protect myself from anybody suing me? It's just nearly impossible to do that because, if you're in business, if you're dealing with people, there could be misunderstandings, and it sometimes lead to some type of lawsuit, or it could be an event that could happen that will lead to a lawsuit. There are ways you can protect yourself to mitigate the damage, to reduce your exposure, and there are ways to do that. I've mentioned this as well. One of them is obviously getting the proper insurance. And having a good conversation with your insurance broker about exactly what you need and making sure that your insurance covers what you need. And I'll give you some examples and I'll give you an example of how this is important. And I've had this happen to some of my clients recently that they believe they have the proper coverage. They request the coverage. For some reason, in one case, the insurance agent did not properly submit the coverage, the information to the insurance carrier, and the policy came back without the proper coverage. So when they got a lawsuit, then it got denied, the claim got denied, and they basically are exposed not only to the claim coming in as a result of the lawsuit, but also legal fees will have to be borne by that client. So having the proper insurance is important. And I think I'll bring somebody in to tell us the types of insurances that a business owner should have, so that way you are protected. But important to read those policies carefully to make sure that the event that you're trying to protect, it is covered. The second one is good contracts. Having good, solid contracts that outline the terms of service, the terms and conditions, the dispute resolution policy, all that. Good contracts help you reduce the likelihood of litigation. You're not going to eliminate it 100% unless you decide not to go into business. Okay, but the objective is to reduce it significantly, so the odds are you will not get sued. Okay, so that's the way I look at it, more of a two-pronged approach here. Having the insurance coverage, whether it's professional liability insurance, errors and omissions, general liability insurance, for example, those will help you, create a buffer that will give you, at the very least, the defense of the claim, if not 100% identification in the case something has to be paid out, and then having solid contracts to make sure that whoever you do business with, there's a clear understanding of what services you will provide, and also if there's a dispute, how they will get resolved. What is the agreement, how you would agree to resolve them. An example would be, first we'll engage in good faith negotiations. If that does not get resolved that way, we will agree before any lawsuit is filed, for example, then you decide to go to a mediation, to hire a neutral mediator, which are many in South Florida, that will help you try to resolve the matter on a confidential basis. And that way, and there's a good opportunity, a good chance that the matter will get resolved at the mediation conference once the mediator explains the potential cost of pursuing this further and going into a lawsuit. Having that honest discussion about what it will take for you to have a trial on the merits and the cost involved. So that's just an example of having, that approach. And then the third approach, whether it's going to litigation, whether it's going to arbitration, that is something that should be done at the last resort. But you can have a stepped approach in reference to how to resolve disputes, and that could be part of your contract. An attorney can help you with that. So one of the issues that I'm facing that is very common is that sometimes the cost of litigation can exceed the actual amount of controversy. And I'll give you an example. If you have, say, a $25,000 breach of contract claim, say it deals with some type of construction defect or some type of maybe a kitchen was not done properly, that the owner is alleging that the contractor did not do the installation correctly, or something that, a bathroom that was not done well. So in the amount of controversy, say $25,000, for instance, based on the type of witnesses you have to bring in, maybe you will have to hire an expert to make a determination and testify on your behalf that, yes, this is not done according to industry standards. You could easily exceed $50,000 on a litigation claim when it's $25,000 in controversy. So, and why is that? Okay. There's a lot of things that go behind the scenes, and I believe I did that 2 episodes back about really what goes behind the scenes in the litigation process. And I know sometimes it's frustrated to you as the client that sometimes you don't know what's going on in the case. There's activity happening in the background that you're not aware of because simply it is in the background. This is the way it's supposed to be. And an example of that would be, we're scheduling hearings for motions to dismiss, or what I call motion practice. We have motions to compel discovery, dealing with objections to discovery. So those hearings are scheduled with the court pursuant to the court's schedule, and usually a paralegal handles that in terms of scheduling those hearings. And there's a lot of coordination that goes along between, say, in the case, our office and opposing counsel's office to find dates that everyone is available to have that 15-minute hearing with the judge. So that is, so it's a lot of things go behind the scenes and you don't really get involved in that. That's something that the attorney's office handles directly. There's a draft of documents that we have to do. So you don't see the drafting process. You see the final result of whatever we're drafting on your behalf. Sometimes you go to 2 or 3 drafts, depending on the type of motion that it is or response. And those things take quite a bit of time to prepare. And you see the outcome. And sometimes you say, okay, there's 5 pages of a pleading, and it took 3 hours to do. Well, yeah, but the information was gathered as a result to prepare that particular pleading. It could take that amount of time. Especially there's a lot of discovery involved. Depositions, preparation for deposition sometimes take just as much time, if not even more, of the deposition time. In some cases, you got to go through, thousands of documents. You got to go through interrogatory answers. You got to look at the pleadings. You got to look at the case law, and preparing the questions that you're going to ask the deponent, the party or the witness, to make sure you have a productive deposition and you'll be able to extract or elicit the answers that you need to prove your case. So that takes quite a bit of time, plus the time of actual depo that you got to take. And in some cases, does not finish that first day, had to be continued for a second day. So there's a lot of things that can add up to the cost. Okay. But there's some hidden costs as a result of litigation. And then I'll tell you things how we can do, or you can do, to reduce your cost in litigation. You're not going to eliminate it. If you're in another lawsuit, it's not going to be eliminated, but you can try to be efficient in how you can reduce your cost. But there's some hidden costs with litigation. There's loss of productivity. You will be distracted. That's going to be in your mind constantly, simply because you're in a lawsuit, and it's not normal for anyone to be in a lawsuit, whether it's you're the one suing or the one that is being sued. It's not something that you're usually involved with. So it'll be some distractions there. There's going to be stress. And in the business could be a disruption of business operations as well. If you have to let go an employee simply because you don't have enough funds to pay that employee, but you get paid for the litigation. So there's some, hidden costs that are, not as tangible or as money, but it's certainly there's a great deal of stress involved with litigation. A question that I get often is, okay, can I get my money back when the loss? Can I win those fees? And I want to talk about that a little bit. Okay, if you have a statutory claim that you're pursuing, for example, the Florida Deceptive Trade Practices Act, for example, they have reciprocal attorney's fees if you win or you prevail. If you lose, they can seek attorney's fees from you. Okay. Or if you have a claim in your contract that says prevailing party is entitled to recover attorney's fees, then you can seek attorney's fees as a result of it. Now, it's not as easy as it sounds. It's not automatic. So say you win your case, okay? You win your case and you want to recover attorney's fees. Well, in order to do that, then you have to file a motion with the court, a motion for entitlement to attorney's fees. And the court first has to give you the entitlement to that. And then the court will issue another order that will be done through an evidentiary hearing unless the parties agree that to an amount. And then the court issues an order that you have to provide opposing counsel all your bills and records, your time statements, your costs, your expenses, and then in some cases you got to hire an expert to look at the bills and then make a determination, make an expert report that you have that the attorney's fees are reasonable, and that is presented to the opposing side. The opposing side can say yay or nay. If they say yes, we'll go with this, and we agree those are reasonable attorney's fees. If they challenge those attorney's fees, then they got to hire an expert on their own to basically look at your bills and then determine whether or not they're reasonable. All that is then presented in an evidentiary hearing with the judge. As you can hear me or see me if you're on YouTube, you already see that's already costing more money to try to get your fees. So in most cases, the best case scenario is basically negotiate a fee structure, a fee amount, and that way it goes into the final judgment, and all that can be avoided. So that is a better approach, but it's not automatic that you get those attorney's fees. You got to seek, you got to file the motion, you got to have a different litigation as a result of it. And then if, say, the other party does not agree, you go to an evidentiary hearing, the judge awards attorney's fees. Those fees, that particular ruling can be appealed as well to the appellate court. So you're not done yet as well. And you still got to pay your attorneys to try to fight for those attorney's fees on top of the fees you already paid, say, and you won your case. So a way to reduce that, that type of litigation is coming with an agreement that you would have, that you agree to. These are the fees that either you got to pay or the fees that the other party will have to pay, even if it's discounted simply because you want to avoid additional litigation. And the judge also can send you to mediation just to mediate that particular point. So it's like Groundhog's Day. You might end up doing this twice in terms of going to mediation as a result of any type of fee dispute. So I just want to give you some thought on that. Okay. Ways that you can save money in litigation. Okay. You got to pick and choose your battles. Okay. And an experienced attorney will tell you which battles to fight, which battles to let go, that are not worth it. Okay. Over litigation is a way that people continue, increasing those fees. And an example of that is that you have a list, say, of 25 potential witnesses that might have a knowledge of the litigation. Okay. They can contribute something. Okay. As I mentioned before, deposing 25 witnesses can be very expensive. Just and court reporter fees. So you can prioritize which are the 5 witnesses that are essential to this case. And you prioritize those witnesses. Okay. Another one that is an area that is what is called poor discovery management. Okay. Not meeting deadlines. If the attorney asks you to provide documents and you're not thorough enough in providing documents, or you give them in a way that are just disorganized, are very difficult to kind of put together and make sense of them, that is going to cost you more money because the attorney has to organize them for you and to be able to present them to the opposing counsel. And they have to be indexed as well. So the more you do regarding the organization of documents, the more time will save you and more money will save you, because then the attorney will not have to do that. That's something you can do because they're your documents in the first place. And they're business documents. There's no reason why they should be disorganized. Okay. Ignoring deadlines. If the attorney tells you, we have 30 days to get this to opposing counsel, I need you to give it to me by the 10th day from today. Give me the initial documents. By the 15th, we're going to have a draft to work with. We're going to meet. By the 20th day, we should have a good working draft. By the 25th day, we should submit them out. Let's not wait to the last minute. But if you don't comply with your attorney's request and then send the documents in the 29th day of the deadline, the attorney has to request an extension of time from opposing counsel in order to be able to prepare those documents or those interrogatories or discovery requests on your behalf. So that's another area that you can save money. Just be organized, be thorough in your answers, so that way you reduce the time the attorney has to go and and go through those with you. Expert witnesses, making the determination when to bring an expert witness and if it's necessary. Expert witnesses cost money. And whether you need them or not, that's a determination you got to talk to your attorney. But that's something that they're very expensive, and in some cases they're not needed. Okay, but you got to make the determination. Communications gap. It's important that you and the attorney are aligned in the goals and objectives of how you want the case resolved. And sometimes that changes. So it's important to communicate with your attorney if anything changed through the strategy, anything changed regarding the outcome that you like to have, because we only know that from you. And in a business dispute, there are many different ways to resolve a dispute. Okay? It's not for example, in family law, it's divorce. I mean, it's clearly they're going to separate, they're going to go separate ways. And in dealing with children, you're dealing with who's going to have which nights. That's a different, that's where the creativity comes in. I don't do family law, but I'm just trying to analogize that the outcome in a business dispute can be different. It can be, you have a lot of different options to explore, unlike other areas of law, of litigations. Okay, but it's important that if you change your perception of the case and you say, you know what was important to me when we spoke initially is not important to me now, but this is more important now. Communicate that with your attorney, because that can make a shift in strategy as well. This one, emotional decision making, is important, and I. I this in my book, Business SOS, about 8 common legal mistakes business owners make and how to avoid them, is that staying in a lawsuit or maintaining a lawsuit as a result is a matter of principle. And I hear that often, so it's about the principle, it's not about the money. Well, principle costs money. And you have to be, honest with yourself about whether or not is it worth it to fight a battle as a result of principle, because it's going to cloud your thinking in how you pursue litigation. And the business dispute is about money, or it's about rights that you have within the business or rights that you had with the business. But most of the time it's about money. Okay? So you have to take this more of as a business approach and not as a principled approach. And there are exceptions to that, and I'll go over that in a second. So you have to kind of look at that and make a determination how important it is to you to continue that, or is this something else you'd rather do with that money as opposed to fighting a principle? So I want to share that with you just simply because there are a lot of people that say, I want to continue this lawsuit because of principle no matter what. I mean, that's their choice, it's their money. But at the end of the day, there will be a winner and a loser. You can end up losing and paying the other side's attorney's fees as a result of principle. Just keep that in mind. Another way to try to reduce the expense of litigation is to mediate early. And I'm a big proponent of mediation, as you know. And I think that the sooner the business owners get into a mediation conference, the better for them, simply because it's an opportunity to attempt to resolve the dispute. It doesn't mean that it'll get resolved, but it is an opportunity. And so I don't think that people should miss an opportunity to talk about the dispute. And sometimes people spend 4 and 6 hours trying to resolve the case, and the mindset shifts at that point from litigating to resolving it. And in some cases, 2 or 3 days later, I get a call from opposing counsel, you know what, my client reconsidered that offer. Let's talk about it, see how we can make this work. Simply because the mindset shifts. And also there's a lot of information exchanged between in a mediation that it is confidential. It cannot be used in the case, but it's information that's valuable because in many cases, you get to understand the other side's point of view of the lawsuit. why they're suing you, what is their perception. You get to know whether this case is strong enough or not. The strength of witnesses, you find that out in a mediation, even though it cannot be used in a court proceeding, but that information is valuable. And at the same time, you have an opportunity to listen to your point of view on the other side that is only being presented by the attorney through pleadings. So having those conversations are very helpful. Even if you do not settle, it is helpful to have that mediation. So mediating early, it is something that I do recommend. Have a point person in terms of discovery. If you have a point person in the company that can be the liaison with the attorney, if it's not you, with respect to getting documents, delegating that could be helpful as well. Again, the more organized you are with respect to providing documents, the better it is for the attorney, and it's also better for you because you will help your case by assisting the attorney providing and getting that information. And this one is, what I call control the scope of the case. Staying focused of what you're trying to accomplish is very important. A defense will send motions that are distractions. We'll try to pick up a fight on a discovery issue just simply to keep the attorney distracted. This is a little bit of gamemanship that goes on, but understanding what they're trying to do, what this guy's trying to do, and staying focused on the strategy and the goals that you have is very important. So avoiding unnecessary distractions is the key here, and not overreacting when they file something. And I remind that to my clients, this is part of the process. They're going to be filing a lot of things, okay? Not overreacting when something is filed, and they're going to say things that might not be true. They might have things that are inflammatory. It is part of the process. An attorney understands how to handle that and how to respond. But overreactions is something that it creates additional stress, and also having your attorney explain the whole process to you would also cost money, even though it's important for you to understand it. But a lot of times the opposing side does that on purpose, simply to create a distraction and to create stress. Setting up a litigation budget as well. Tell your attorney and tell them, this is the money that I have to spend on this case. And your attorney will tell you, okay, I can work with that budget or I cannot. Or if we have that budget, then we need to streamline this and skip a few steps. We're not going to take everybody's deposition. We're going to take a few depositions. We're going to focus on this particular aspect of the discovery. We're going to focus on this part of the case. Okay, that's all you have. Okay, so you have to tell the attorney the type of budget that you have to support litigation, so the attorney can do an assessment whether or not that's sustainable or to up to what point. So that discussion should take place. In terms of preventing lawsuits, and that's the things, the cost savings that I wanted to share with you. Further, I want to go into when fighting is necessary, okay? There are some times that cases should not settle or will not settle, okay? And I think that one of them might be protecting your intellectual property. If you have a trademark and somebody's infringing your trademark, you might have to file a lawsuit and protect that trademark. So that's just one example, or a patent or a trade secret. There are reasons why you need to file the lawsuit, okay? Defending your business reputation against false claims, or your reputation, individual reputation against false claims, defamatory statements, any libel or slander against you that affects your business reputation. Those lawsuits may not be settled or could be settled with the proper procedure, retraction, apology, money, different ways, but there's a reason that those lawsuits might be necessary, okay? Enforcing contracts. You do have a contract you want to enforce, has been breached, you might have to enforce that contract through a lawsuit if the party does not comply with the requirements of the contract. So my point to you is that, yes, you want to try to mitigate the exposure of you being sued, but there are times that losses are necessary in order to protect your interest. And the way you have to make an assessment of the cost, the outcome that you want to achieve, and the attorney will help you make that determination whether or not your case is viable, your chances of success, although nobody can guarantee outcome because you're dealing with a jury or a judge. But at the very least, an attorney can tell you, listen, you have a good case. These are the concerns that I have, and discuss that with you. So there's sometimes that losses are necessary, and we have to pursue them. But you have to be mindful that even if you're right in the case of filing a lawsuit, it's going to cost a lot of money, and sometimes you can end up getting a counterclaim. And even if you decide at some point, I don't want to proceed with the lawsuit, that counterclaim does not go away. So every time you file a lawsuit, there's always a potential exposure that you can actually be sued back in a counterclaim. And then even if you want to walk away, the party may say, I'm not walking away. You end up paying money to get rid of that counterclaim. So just keep that in mind. The last point I want to make is because it's happening lately is that, trying to be co-counsel to your attorney, it's just not a good idea. Okay. Your attorney's a professional. He's experienced. He's the one that knows how to navigate the litigation process. But lately, because the assistance of AI models, where ChatGPT, which is the most popular one, and then you have other ones out there that people are using, they basically want to now become your second chair or co-counseling in the case. It's not helpful. It's not helpful. Just ask questions that you have concern, but trying to be co-counsel in the case, it's just going to cost you more money because the attorney then have to go back and explain to you why that particular issue, that particular strategy might not work or why it will not work. But you're taking additional time from your attorney trying to second guess that attorney on what his or her decisions on strategy might be. So I just want to share that with you. This is good for today. I truly appreciate you listening to me. Hope this information was helpful to you. And if you are in a type of litigation that maybe these tips help you reduce those expenses and try to get you out of that lawsuit as soon as possible. I want to, again, thank you again for listening. I want to wish everyone a happy Thanksgiving and a happy holiday. If you want to reach me, if you have any questions about any of the topics that I've covered so far, you can reach me at richsierra.com. If you want to learn more about our legal services that we offer, my website is floridasmallbusinesslegalcenter.com. We're also on YouTube. If you want to look at our YouTube channel and watch this video on YouTube, it's youtube.com/@RichardSierra. And our phone number is 866-842-5202. Until next week, this is Rich Sierra. And remember that my goal is to help you succeed.